Take a look at this. Ripple CEO criticizes SEC for disregarding XRP court decision, alleges agency exceeds its jurisdiction. The chief executive officer of Ripple, Brad Garlinghouse, has increased the amount of criticism directed toward the United States Securities and Exchange Commission. He has stated that the agency is disregarding a significant court order in which the XRP coin was categorized as a non-security. This came about as a result of the lawsuit that Binomial Exchange had filed against the SEC, which challenged the ability of the regulator to impose authority over XRP futures contracts. As a result, this action serves as an indication of the growing conflict that exists between cryptocurrency companies and the Securities and Exchange Commission, with many individuals believing that the SEC overexercises its role in the regulatory process. According to Garlinghouse's most recent utterances, it is abundantly evident that he is of the opinion that the Securities and Exchange Commission is acting in an excessive manner with regard to Ripple and XRP. His comments were in response to the lawsuit that Binomial had filed, in which they asserted that the SEC does not have authority over XRP futures and that the CFTC ought to be the individual responsible for regulating these transactions. Garlinghouse stated the following in a post that he made on X's social media platform: a new low for a renegade agency that many thought couldn't sink any further. Despite a court's decision that XRP is not a security, the Securities and Exchange Commission now claims it may operate beyond the law. After that, he made a commitment to keep a close eye on the situation and investigate the possibility of pursuing a course of action that would expose the Securities and Exchange Commission for what he considered to be an unlawful overreach. An assault on the purported shared oversight that the SEC is supposed to exercise over XRP futures contracts will serve as the basis for this action. The exchange contends that XRP futures shouldn't be categorized as securities and hence should not fall under the jurisdiction of the SEC. This is because the exchange argues that these contracts do not qualify as securities. This aligns with what Garlinghouse says about the SEC's ongoing overreach into regulation, which he believes impedes innovation and advancement inside the Bitcoin field. This is in line with what Garlinghouse argues. In point of fact, Ripple has been engaged in legal proceedings against the SEC since December of last year, when Ripple sold $1.03 billion worth of XRP through unregistered securities offerings. The agency filed a lawsuit against the company. Ripple contended during the entirety of the litigation that XRP was not a security position. This assertion was partially vindicated in July 2023 when District Judge Analisa Torres ruled that the programmatic sales of XRP on open markets do not constitute transactions of securities, despite the fact that she issued a directive stating that direct sales of XRP to institutional investors can in fact be considered security transactions. There is still a great deal of ambiguity around the regulatory landscape. A cross appeal was submitted by Ripple in response to the SEC's appeal of the judge's decision, which was filed against the judge's decision. The Securities and Exchange Commission, he and the rapidly expanding cryptocurrency industry are engaged in a number of ongoing skirmishes about who will have the authority to regulate cryptocurrencies. The conflicts have frequently resulted in quite vociferous and relentless criticism from the chief legal officer at Ripple, Stuart Alderodi, and his staff. They appear to detect overreach in the behavior of the SEC, as well as constitutional issues concerning the boundaries of its authority to exercise regulatory power. Many members of the cryptocurrency community are outraged by the attacks that Garlinghouse has launched against the Securities and Exchange Commission. This community believes that the SEC's actions not only serve to undermine the interests of innovation, but also serve as a symptom of a more widespread struggle for regulatory clarity in the industry. In light of the fact that cryptocurrency markets are anticipated to continue developing over the course of time, it is not yet clear to what degree the outcome of these legal disputes will impact the manner in which digital assets are governed in the United States. Matter is made even more complicated by the fact that the Securities and Exchange Commission, and second, the Commodity Futures Trading Commission, CFTC, digital assets. Despite the fact that the Securities and Exchange Commission is adamant about the regulation of securities, the Commodity Futures Trading Commission, FTFT, typically views certain Bitcoin contracts as commodities. This fractured regulatory picture caused firms to become confused about cryptocurrency, which in turn sparked calls for the regulators to provide more clear guidelines. Considering that Ripple and the majority of other cryptocurrency businesses are currently navigating turbulent waters with regulatory updates, Garlinghouse's statements have recently brought a new degree of significance to the situation. Battles in the courtroom that are currently taking place have the potential to influence more than just the future of Ripple and XRP. In the meantime, the natural and keen interest will come from stakeholders and watchers within the industry. This is because the legal battles between crypto businesses and regulatory authorities such as the SEC will continue. The latest development in the long-running legal battle between Ripple and the U.S. Securities and Exchange Commission has ignited heightened uncertainty regarding the future of XRP. Despite gloomy forecasts, many community members are holding out hope that the asset's price will rise. XRP, one of the more daring predictions, was supposedly made by Avenger, a well-known figure in the cryptocurrency community. According to Avenger's essay, the price of XRP can surge to new heights when the cryptocurrency wins its appeal. In his ideal world, the token would reach $40 simultaneously with Ripple's announcement of new partnerships with US-based clients and the development of items involving digital currency. Notably, Ripple has filed a cross appeal, and Stuart Alderando, chief legal officer of Ripple, has stressed that the business will leave no stone unturned after the appeal. Complete and utter clarity regarding the digital asset's legal status would ensue from a victory for the firm. In addition, XRP Avenger anticipates that the number of US financial institutions using XRP will grow, which would elevate the token's price. However, not everyone believes that these optimistic projections are correct. Doubters hold the view that XRP price fluctuations have, in the past, lagged behind expectations. Despite the significant court ruling, an individual user raised this issue by saying, this was stated following the case's summary decision in July 2023. There aren't enough people interested in XRP outside of your little group to warrant its consideration. An often heard gripe is highlighted by this comment. Ripple has achieved a lot, but its token has struggled to gain traction beyond its original supporters. After someone else raised an important point about the expectation of a large price increase, it was brought to light that the whole market capitalization of XRP was there. The market capitalization would need to hit around $80 before it could reach around $1.50. For XRP to see even small price increases, a substantial quantity of liquidity is necessary. Loan. Avenger has identified $40 or $500 objectives. The statement emphasizes how important this necessity is. In addition, the users expressed the opinion that banks will likely employ Ripple stablecoin rather than XRP. This indicates that XRP's practicality might not be the driving force behind its demand that many anticipate. A federal judge concluded that the SEC lacked proof that Ripple violated securities laws by selling XRP to ordinary customers on exchanges, the company's core technology, throughout the previous year. A subsequent announcement indicated that the CC would be appealing this decision. As a result, Ripple has added another layer to the already complex legal case by filing a cross appeal. This is the substance of a Thinking Crypto podcast episode. While the exact goals remain unclear, its attorney James Murphy stressed that they are likely appealing to key elements from the decision by contesting the judge's determination that sales of Ripple on exchanges do not constitute securities transactions. In response to the judge's ruling, the SEC will file an appeal. That's all for now.